So good morning, once again, and welcome to our Sunday service. Regarding Justice Ruth Bader Ginsburg, or RBG, as she's kind of fondly referred to, she passed away recently, and of course, in Buddhism, this is an example of the teaching of impermanence. Specifically, the loss of someone. Very important to us as citizens of the United States. And then I think, as you've probably seen on the news, or maybe locally, it's also an example of interdependence, because we're witnessing the sincere outpouring of many very public expressions of loss in the media, and at the Capitol, where she currently lies in state. And my own appreciation of Justice Ginsburg was actually, I was always very aware of her, of course, but it was, I would say it was deepened back in 2015 when I happened to host a discussion group at the temple. The occasion for the discussion was the landmark decision by the Supreme Court to legalize same-sex marriage. You might remember that was a fairly major decision, what do they call it, a landmark decision by the Supreme Court in 2015. And that decision was based on the legal interpretation of the 5-4 majority. And so I think that majority of which Justice Ginsburg was a part of is, of course, threatened now. And so that's one of the reasons why it's a very significant event, her passing is. But during my research for the discussion group, I happened to come across a video from 2006 that was featuring her. And actually, in that video, she discussed the, that's my phone there, sorry. I have to turn that off. She discussed the critical role that the 14th Amendment of the Constitution played in various landmark Supreme Court decisions. And of course, in 2006, that video had been filmed before the legalizing of same-sex marriage. But I thought you might be interested in a little later in seeing a couple of clips of her, because these clips help explain that later 2015 decision in favor of same-sex marriage. And this video that I discovered was a recording of a Q&A where 48, I would say very lucky high school students from across the country were invited to travel to the Supreme Court and discuss, in particular, the origin and importance of the 14th Amendment with Justice Ginsburg. And just as a side note, that Q&A was sponsored by the Annenberg Foundation, and it's on the internet. I can't remember the URL for it, but if you look up, well, I think I guess I can post the link later on in the Facebook page when I locate it, if you're interested in seeing the whole video. But anyway, in the video, Justice Ginsburg, I'll just refer to as RBG, she begins by reading the 14th Amendment, which says, the most important part of it says, "No state shall deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws." So the first part is known as the due process clause of the 14th Amendment. No state shall deprive any person of life, liberty, or property without due process of law. The second part is known as the equal protection clause. And it says, no state shall deny to any person the equal protection of the laws. And RBG also states that the reason for the 14th Amendment is that, back in 1787, due to the very heated debates over the issue of slavery, which, in 1787 had not been resolved, amongst the framers of the Constitution, there was no equal protection clause in the original Constitution. So when they ratified it in 1787, there was no equal protection clause. But she adds, there is an important statement in the earlier Declaration of Independence, which was written 11 years earlier, as we all know, in 1776. And that statement in the Declaration of Independence is, we hold these truths to be self-evident, that all men are created equal. And so then, as she states in the video, quote, there was therefore at the dawning of our nation this statement that all persons are created equal, but nothing about equality in the original Constitution, end quote. And so the 14th Amendment was drafted later in 1868, after the Civil War, to address that deficiency and then guarantee equal protection to the newly freed slaves. But now let's listen to RBG explain how over time other demographic groups in the United States were able to also receive the 14th Amendment's guarantee of equal protection.
The Supreme Court early on said the 14th Amendment was so obviously intended to grant equality to the former slaves that we don't think it really applies in any other situation. But over the course of now a century and a half almost, the Equal Protection Clause has expanded. It has grown from the core purpose to protect the newly freed slaves to encompassing more and more people. I like to think of it this way. Who can tell me the very opening words of the Constitution of the United States?
We the people, in order to form a more perfect union.
Exactly. Those two clauses, we the people of the United States, in order to form a more perfect union. Who were we the people? I think there was an answer to that earlier. We the people were white men, but even that was too large a category. We the people were white property-owning males. So the original we the people was a rather elite group. The genius of the U.S. Constitution is that over the years, we have formed a more perfect union by encompassing more and more people who were once left out. Slaves, Native Americans, and one other group. Yes?
Women?
Yes.
Yes. And I think, as you all know, especially if you're a woman, that it was in 1920 that the 19th Amendment granted women the right to vote. But, I personally did not know that that the 19th Amendment was actually based on the 14th Amendment's Equal Protection Clause. Excuse me. So Ruth Bader Ginsburg is of course, she's discussing law, but I personally find her statement that quote, over the years we have formed a more perfect union by encompassing more and more people. I find that statement to strongly resonate with the egalitarian support for inclusivity that's inherent in the teachings of Buddhism. And then, in the same video, I don't have this clip here, but later on, she goes on to clarify another landmark Supreme Court case, which was the I do have this clip. I'm sorry. The Brown versus Board of Education case. I'm sure many of you remember that in 1954. That relied on the 14th Amendment, but first she discusses two cases that preceded that Brown v. Board of Education case, and one is the famous Dred Scott case. I'm sure if you studied American history, you remember that case. That's the case that precipitated the Civil War. And then another case that she discusses is the Plessy versus Ferguson case. This case is the one that established what are known as what we know as the Jim Crow laws. And the question that she's asked before this next video, which I will play, is how has the Supreme Court's approach to racial discrimination changed?
Court's approach to racial discrimination changed across time?
I'll ask you about a case that probably you have heard of to illustrate how it has changed. Let's start with a case from before the 14th Amendment, from before the Civil War. Well, what the Dred Scott decision said was no person born of a slave can ever be a citizen of the United States and remains the property of its master, even if it is taken into a free territory. That decision so incensed we the people that it helped to precipitate the Civil War. Well, then the Civil War is over, and we have the 13th, 14th, and 15th Amendment that makes the former slaves part of we the people, voters. But then there's a decision in 1896 called Plessy against Ferguson. Can someone tell me what that case was about? Yes.
The court ruled that as long as the schools and other facilities were separate but equal in standard, that discrimination could be allowed.
Plessy against Ferguson upheld the so-called separate but equal doctrine. And the case itself was not about schools. It was about accommodations. We had, if truth be told, in America at the time, a system not so far distant from the system in South Africa. The separation, the law-enforced separation of the races. The word in South Africa is apartheid. Laws saying the races should not mix. They are entitled to equality, so separate but equal schools, separate but equal places on buses, on trains, in movie theaters, even in courtrooms. That was the understanding in 1896. And then let's fast forward to 1954. And the Supreme Court decides the case of Brown v. Board of Education and says that separate but equal was a misguided doctrine, and equal means together, we the people, forming a union with no separation of people by race, national origin, etc. We the people are one. We are many, e pluribus unum. We are many, but we are one.
So I don't know if you're aware of it. Maybe most of you probably are. But on the back of the $1 bill there, you can see the Great Seal of the United States, and above the wing of the eagle there is the phrase, the Latin phrase, "E pluribus unum." And as RBG said, we the people are many. We are many, but we are one. Or as it's often translated, out of many, one. One out of many, or out of many become one. So I'm not saying that RBG was a Buddhist. She was Jewish, of course, but not of course, but she was Jewish. But nonetheless, as a Buddhist myself, I like to think of her as a kind of a bodhisattva. We call it bodhisattva, someone who devoted their life to making the United States a better, more compassionate, and more inclusive country. And I think that, especially in that last statement, where she emphasizes this phrase, this Latin phrase, "E pluribus unum," out of many, one, we can see that her underlying understanding of what is true and what is real is clearly in accord with the teachings of Buddhism, with the teaching of the oneness of all life. And actually, one of the other interesting things in this video is how she discusses the way the Supreme Court itself has changed over the decades. I wasn't able to include this segment. But after that first clip that I showed earlier, she goes on to highlight that, not only, how women won the right to vote in 1920, but that then in the 1970s, about 50 years later, in the 1970s especially, women won more guarantees of equality, especially in the workplace. And she says that this was due to societal changes. For example, by the 70s, more and more women were working. Most households were two-income families, and then of course there was the women's liberation movement, and so forth. And as she put it, the Supreme Court itself is basically a reactive institution. From a Buddhist perspective, that's a liberal perspective, by the way. That's not the conservative perspective, but it's a reactive institution. And I think from a Buddhist perspective, we could say the court itself, the Supreme Court itself, is in fact subject to powerful national and international causes and conditions that shape the attitudes of the justices. And so this is, I think another example not only of impermanence, but also of the interdependence of all of us. I think there's also a more, specifically, I would say, Mahayana Buddhist element. And I think we saw this when she asked the students about the opening words of the Constitution, and then the one student answered, "We the people of the United States, in order to form a more perfect union." And in that opening part of the clip there, her point was that the definition of exactly who we the people were changed over time from originally just being white male property owners, which, as she says, is a very exclusive group, to then include Native Americans, African Americans, women, and then of course in 2015 same-sex couples. And she says that the genius of the Constitution is that the framers knew they hadn't created a perfect document, but that the phrase "in order to form a more perfect union" allows for the Constitution to change and gradually become more and more inclusive. So, I think probably most of you know the word Mahayana means great vehicle, Mahayana. And some people might interpret the word great to mean something like superior, or better than the other large branch, which is, sometimes sort of derogative fashion called Hinayana, or small vehicle, but actually it's the proper term, I think, is Theravada, or the way of the elders. But Mahayana, the word Maha, which means great, I think really here means something like supremely or infinitely inclusive. That's what it really means. And in other words, where the Theravada or the monastic path is the more difficult path that is mainly suitable to a fairly select group of monks and nuns, the Mahayana is the path of enlightenment for all people, the path of enlightenment that includes all people. And so I think it's very heartening to hear RBG state in that second clip that, as she clarifies, separate but equal, which is a misguided doctrine, she said. Separate but equal is not equal. That equal means together. So in other words, as she said, and I'm quoting her, we the people forming a union with no separation of people by race, national origin, etc. We the people are one. We the people are many. E pluribus unum. We are many, but we are one. I don't know if if you see the parallel here to what we just recited at the beginning of the service, the three treasures, the statement about the Sangha says, "May we together as one, uniting in harmony, strive to live for the enlightenment of all beings." We could change that to "May we together as one, uniting in harmony, strive to live for the inclusion of all beings." I think it's the same idea, obviously. But going forward, we certainly, we hope for the best in terms of Justice Ginsburg's Supreme Court replacement, who was recently announced. But we don't know how things may change. Of course, I'm sure they probably will change. But and of course, I think I would say there are various, shall we say, unawakened powers that are at work in our contemporary political scene, or we could say, instead of unawakened, we could say less inclusive attitudes that are at work in our contemporary political scene. And we only have limited control over this, but we do, of course, have the right to vote, and we have our vote in November, and I think we should obviously, for ourselves, and in honor of Ruth Bader Ginsburg, that we should not only vote, but encourage everyone that we know to vote. I mean, this, as we saw in her sort of history of the 14th Amendment and how it's become granted more and more people the right to vote, it's, in a sense, if we don't exercise that right, it's not doing her honor. It's not honoring her work. But regardless of how things turn out in the long term, I think we can keep a more hopeful or optimistic view, because as she herself noted, at times, we the people have taken a step or two backwards, right? As we did in the Dred Scott case and the Plessy versus Ferguson case and so forth. But eventually, the Constitution's underlying support for equality allowed we the people to address those deficiencies. And I think, as RBG herself pointed out, the Supreme Court, is itself impermanent and changes with societal and political changes. And whatever happens this fall, in the election, I think, as RBG has said, we can, despite the occasional steps backward that we take, hopefully continue to progress towards creating that more perfect union. And I'm hopeful that we will be able to do that. In conclusion, I just wanted to add that in the same way that Justice Ruth Bader Ginsburg, that her words are quite moving, I think we can also be moved by the words of the Buddha. The Buddha is always encouraging us to awaken to the reality that we are not each separate, independent ego selves, that we're all part of the same impermanent and interdependent flow of all life. And that so ultimately, we are all one. E pluribus unum, to put it in Latin. Anyway, that's my sort of thoughts on the passing of Justice Ruth Bader Ginsburg. Thank you for listening. Namo Amida.